overbroad. The second feature...
As you go to the second feature, just know that the 10 minutes is up.
Thank you, Chief Justice. The second feature of the legislation is that it does not require any causation. So there is no need for the speech to have any effect. So it is truly, Chief Justice, a punishment for speaking. The third element... Yes, Justice Draft.
Your clients are represented in Parliament.
Yes.
And it is the duty of Parliament to see to it that legislation that was passed by the apartheid Parliament, which doesn't belong to the statute book now, is removed.
Yes.
And that has not happened.
Yes.
Why?
Well, certainly not for lack of trying on behalf of the EFF. I know for a fact that they began a campaign 3 years ago for the removal of all apartheid statutes. That campaign has not gained traction. So it's not for the lack of trying on behalf of the EFF.
When it comes to the second one, the Trespass Act, we see an amendment which puts in an addition that seeks to carve out the operation of the Trespass Act against people who are protected by ESTA and PI.
No,
is it only ESTA?
It's ESTA. We do have the act here in the bundle that I handed up. It's only ESTA. That's part of the problem, is that when it comes to PI,
okay,
there is no such exclusion.
Okay.
Whereas the element of unlawfulness is removed by Section 1, capital A,
yes,
of the Trespassing Act.
What should we read into that? Doesn't it suggest that the democratic parliament has embraced the Trespass Act?
Yes. What we should read into it in relation to ESTA is that in Section 1, capital A, it has removed the unlawfulness because it says someone who is protected by ESTA is not occupying the land unlawfully under the Trespassing Act.
To have a lawful reason.
Yes, to have a lawful reason, yes. But what it has done is not to extend that application to PI. And so there is even on a legislative front, there is an incomplete constitutional project because that actually supports the argument we make that the intention was to always decriminalize unlawful occupation of land. And that is why, as far as PI is concerned, the same, but of course here we are in the judicial sphere, but the same intention that is exhibited by Section 1A of ESTA should be applicable. If I could then move on, the third element, which again shows that the statute is neither reasonable nor justifiable, is that it does not even require that the speech must be capable of incitement. One of the statutes we have been shown by our learned friends is the UK statute. The UK statute specifically requires that the speech must be capable of producing an outcome. But we don't have that qualification in our statute. And then, of course, the final point is that there is just no connection at all between the speech and the conduct of the person acting. So that if person X says, I occupied the land because I am landless, not because of what Mr. Malema said, Mr. Malema is nevertheless still guilty on the legislation because there is no connection between the speaker and the doer. So it is truly a crime of speaking. It is overbroad, it is unreasonable, it is unjustifiable. It is a gross invasion of the freedom of speech. So we would submit for those two primary reasons, the section is not accommodated within the language of Section 36(1). But even when we do the tabulation exercise, when we look at the factors that a court needs to take into account, we started off with the nature of the right. What we know is that this court has spoken in the language we have used in the heads rather lavishly about the significance of freedom of speech. Chief Justice, you would have noted that our learned friends say that the rights in Section 16 are only intended to protect certain types of speech, in other words, speech that serves certain purposes. That is simply in conflict with the jurisprudence of this court, because the jurisprudence of this court makes it clear that speech is important intrinsically. It is the intrinsic value of speech that is important. Because as Justice O'Regan put it, to speak is to be human. So the nature of the right that is invaded is one of the most important rights that are enshrined in the Constitution, because it is by speaking that we can play out our humanity.
Mr. Ngukaitobi, the respondent says that the right enshrined in Section 16(1) should not be interpreted in isolation, but one must have regard to the other rights, like the right to property, housing, and safety. And there must be balancing of exercise. What do you say to that?
Yes. The incitement provision does not touch upon property and other rights because it punishes speaking only. They themselves accept that even if the speech produces no consequences that would invade property rights, the speaker is still nevertheless guilty because it is not a crime of doing, it is a crime of speaking. So I'm afraid their argument doesn't hold water in the light of the language of the section. The purpose of the section was always to catch the political leaders, the instigators. It was never to catch the doers. Then the next...
Can I raise my difficulty, and maybe you can help me resolve it? Yes, you say that it is related to speaking. But as you know, and this is where my difficulty is, incitement is not only related to public speaking, it also relates to incitement to commit, it may be, any of the common law crimes. And whilst preparing for this matter, I was worried about that. What do we do? Because if this was simply related to freedom of speech in terms of public speaking or one expressing their opinion, then I would be with you. I wouldn't have this difficulty that I have. But it also relates to commission of crime and incitement when a person is incited to commit a crime like murder, for instance, and all of that.
Yes. Justice Chipko, can I say two things about that? If we look at page 20 of the bundle, because that is where the Act is, the section comprises of two elements. The one element is conspiracy, and the second element is incitement. So if a person, and we have not challenged the conspiracy provision, and what we have noted, our learned friends refer, for instance, to the case of Basson, and they say this court endorsed the Basson outcome. But what is unique about that case is that all of the judgments that they have referred to are conspiracy judgments. So if a person in the same position that Justice Chipko, you are putting to me, is actually involved in the planning and the instigation, even though they don't do, those people are guilty of the crime of conspiracy. And it was exactly the same finding if one goes through the judgment of, in the Basson judgment. They were guilty of conspiracy. So there is no difficulty at all. The second answer to it, Justice Chipko, is that we have not come to court to strike down the offense of incitement in general. And it is the mischaracterization of our case. We have come to court to say that the formulation in Section 18(2)(b) is an unconstitutional formulation. The state has a range of other methods of formulating the offense so that it fits the Section 16(1) requirements of the Constitution. One example is what they have produced themselves, which is the UK example about how the crime in the UK is formulated. So it is not as if we've come to stop the state from having an incitement crime if it wishes to. But we have come to court to say that this particular wording contains features that are an unjustifiable infringement of the right in section 16(1). So there are many ways in which the section may be rewritten. One of them we have provided. The state says that is inadequate. Well, then it must find other alternative ways of formulating the crime of incitement.
My difficulty with that, Mr. Nkatobi, while you're on that topic. So, for example, if I incite a person or persons to defraud Treasury through a tender or some like of millions of rands, but that needs to be done next month when the tender adjudication is done through the bid committee and so on, then potentially I'm not guilty of incitement.
On the version that we have proposed?
Yes.
Yes, I agree with you, Justice Majid, then you wouldn't be. But we would submit there that that would be the price we must pay for protecting speech. But at the same time...
We have seen that it's cost us a lot of money already, so you're saying that we must budget for more of the same?
No, Justice Majid.
Abolishing incitement in...
No, let me just continue to finish the point. The point we make, Justice Majid, is that the one formulation is what we have given, but it does not have to be accepted by the state. There are many other ways of formulating the crime of incitement, which would not be the same as the overbroad crime of incitement in 18(2)(b). So they may complain that our requirement of imminence and our requirement of violence is inappropriate. But that does not mean the state is now not free to formulate the crime differently. The point we make is that the crime must fit the constitutional provisions in Section 16. The current crime is outside those constitutional provisions, and the justifications that they have given simply do not show enough proportionality between the doer and the speaker.
Mr. Ngubengcuka.
And yes, Justice Matopo.
I just want to take you back to 2 points. The first one deals with what you would regard as a breathtaking act. The alleged offenses were said to have been committed somewhere around 2014 and 2016. There was a delay. One never knows why the charges were not preferred, but it's neither here nor there. I just want to posit this scenario. If, for example, somebody were to occupy a piece of land as of today, and says, I'm occupying this piece of land because in 2014, Malema said we must occupy the land wherever we find it. And would Malema then be charged with his utterances in 2014?
Yes.
For an incident that happened in 2020?
Yes. That is precisely the point, Justice Matopo. That is why we say that one of the elements of this offense is that there is no connection whatsoever between the speaker and the doer. Even a speaker who says, I occupied the land because I am landless, not because of what Mr. Malema said. Mr. Malema is still guilty of incitement. Even a speaker, as you posit, who comes in 2016 and says it was because of Mr. Malema's utterances 2 years ago, Mr. Malema is still guilty of incitement. But this is precisely the intention of the legislation. This is precisely what they wanted to achieve.
But then one has to go back to the legislation itself and its primary purpose or object. It says to consolidate the laws relating to riotous assemblies and the prohibition of engendering feelings of hostility between European and non-European inhabitants of the Republic and matters incidental thereto, and laws relating to certain offences. One has to look at the purpose of the Act and ask oneself whether that purpose still finds application currently. And if it doesn't, and we have a problem about the Act itself.
Indeed, Justice Matopo, we would submit that would be a strong justification for viewing this with suspicion on the basis that it does not fit the open and democratic society that Section 36(1) speaks about.
Mr. Ngugatobi, I have some difficulty if competently under the section there could be a conviction where there's a misalignment between the intention of the inciter and the doer, as you put it. If the doer doesn't have an intention to commit an offense, the doer would not be convicted of that offense because the state would have failed to establish one of the elements. Is it not correct?
Yes, I accept that.
Now, what would be the basis of convicting the inciter?
Yes, this is precisely the point that the state has repeatedly stated, that this is the so-called inchoate crime, and that it is enough that you had the intention of inciting, and that it is not necessary to produce any outcomes. And that is how the statute is framed, that is how it is read. And this is precisely one of the four elements that show how overbroad the legislation is that there is no connection between the intention of the inciter. I may intend to incite, and the incited may not even intend to commit an offense, may not even commit an offense at all. They may commit an offense, but they may not even intend committing an offense. But as an inciter, I am still guilty of an offense. And this is the, Justice Jafta, you put it more eloquently than me, this is the misalignment that we say points to the unreasonableness and the unjustifiability of the section.
On another point, you have submitted that this court has already pronounced on the scope of the rights in section 16(1).
Yes.
And I understood your submission to be that that scope is as wide as anything as long as it is speech. Or did I misunderstand you?
Yes, well, it's all of the rights that are in 16(1). It's the right of the speaker and the right of those listening to them. So it is freedom of expression, which includes press and other media, receive or impart information or ideas, artistic creativity, academic freedom, and scientific research. So those four elements.
Well, I am a bit concerned whether we should proceed from the premise that Section 16(1) doesn't have a limited scope. It may well be that in the past there was no need to determine the parameters because of the facts of those particular cases, that there could not be a dispute as to whether speech that was the subject matter there fell within 16(1). I am not quite sure that if that is the position, it means then that any speech would fall under 16(1) except the speech that is mentioned specifically under 16(2).
Yes. Justice Jafta, I think the authorities on the point from this court are quite clear. The Islamic Unity Convention case, and it also speaks at a principled level rather than on the facts of the case. The Deroik case, which was about child pornography, also speaks at a principled level. Most recently, the Moyo case, which is closer to the facts here because it was a crime of intimidation, and specifically stated, that was the entire debate there about what are the parameters of Section 16, and specifically states that as long as it is not speech that is in Section 16(2), then it falls within the protective ambit of Section 16(1). That obviously does not mean the state may not regulate the speech, but if it wants to succeed, it must prove that the regulation fits in Section 36(1). So that is the position endorsed by this court, and it's understandable because of the reasons that have been given, that speech is intrinsically important. There is no need to speak only the right things. Anything that is spoken is intrinsically susceptible to protection.
Yeah, but then it takes us back to the question that was raised by Justice Mhlandla, because sometimes speech may intrude into the scope of other rights.
Yes.
Now the question is that speech protected under Section 16(1) in view of the fact that we don't have a hierarchy of rights? All rights are equal.
Yes.
If it extends to intrude into the scope of another constitutionally guaranteed right, can we still say the scope of 16(1) extend into the scope of another right?
Yes. Justice Schafter, I would say two things about that. Firstly, it's just to domesticate the debate into the Riotous Assemblies Act. So if I occupy land, personally occupy land, then I'm guilty of occupying land. If I conspire about the occupation of land, then I'm guilty of 18(2)A. The problem with 18(2)B is that it specifically focuses on speaking and nothing else. It has no consequences whatsoever for any other right. It is entirely about speaking.
No, I appreciate that, but that does not determine the scope of 16(1).
All right, so you're watching live constitutional court proceedings. The economic freedom fighters have approached the court to challenge the constitutionality of the Riotous Assemblies Act, and they basically want to do this in its entirety. You'll remember in July last year, the Gauteng High Court in Pretoria found that only part of the act was unconstitutional. This stems from the EFF leader, Julius Malema, being charged for allegedly violating that act twice. You'll remember it was in KwaZulu-Natal and in Bloemfontein. And Malema reportedly called for the occupation of vacant land. Now, Advocate Tembeka Ncukaitobi is arguing on behalf of the EFF and saying that the section of the act is not reasonable and it's not justifiable. And basically the intention of incitement is being argued, and it's in sharp focus. And Malema is basically arguing that it criminalizes his constitutional right to freedom of speech. That is currently going on. We'll keep a close eye on that story. But I want to take you now to Parktown, Johannesburg. It's where we find